the purpose of this topic deals with open accounts, where the creditor, I suppose, in hindsight, unwisely extended credit to a firm overseas, let's choose Italy, and now has problem getting paid. So this deals with debt collection, where there has been no security taken in any form. It's based on trust, on a promise. I think you get the message. So that's where the thrust of this is. As if they sold to a person across the street, when indeed it's across the border. And I use the word cross the border. I don't mean Canada and United States. My focus really deals with not only the United States, naturally, but truly foreign. I'd like to be interrupted as much as possible. If I was in a classroom, I would have said, not by tomatoes, please. But I like to be interrupted. I don't want this where some guy called David Franklin is going to talk for, oh my goodness, an hour and a half. Because the attention line, no matter how brilliant, which doesn't apply to me, is, interest begin to wane. So please, let's make this interactive. I wish to be interrupted, because I have no idea whether I'm communicating. Okay, that's the deal. We're not a very large group, and so this should be a learning experience for all, including myself. Any questions up to that point? You have my PowerPoint presentation. I play a bit of chess, and I regard this dynamic of international debt collection as three-way chess, when in fact chess, as you know, is only between black and white. So you have three different law systems quite often in an international collection. I'm working right now on the enforcement of a foreign judgment into Canada. And so you're dealing with the law of the creditor in the foreign country who says, we've obtained a foreign judgment, the debtor is in Canada, can you do anything, Mr. Franklin? Now there are three laws here. Obviously the law of the creditor that entitles him or entitles the court there to render judgment. There's the law of the debtor. Now the debtor is in Canada. Lawyers that are listening to this know the case of Beals, a 2003 case, which gives certain parameters as to whether such a judgment coming from, in that case, Florida, would be recognized. It went all the way to the Supreme Court. So you have the law of the debtor. And then you say, well, where's the international law? Well, one of the defenses a debtor would have, in this case Canadian, is, was the proceeding served under the Hague Convention? So the Hague Convention obviously is a treaty that Canada has signed on to and gives the mechanics of serving civil or commercial papers abroad. Even in the Supreme Court case, they talked about comity, C-O-M-I-T-Y, which deals with international custom of recognizing foreign judgments. So you can see that it's not two-dimensional. At times it's three-dimensional. Now, in this game, let's call it that, there are two types of collections. There's retail. That is what it's called in this industry, retail versus commercial. I trust that this audience is interested in the commercial. Commercial means business to business. Retail means business, like a bank, that has accounts against individuals. Now, my presentation does not deal with personal debt. For those that are venturing into that, and you have claims into other countries, which is the purpose of the seminar, right? Claims into Canada, let's say into the United States. I myself, when I get claims from Canada against individuals living in the United States, I basically immediately hand it over to a lawyer in the States because of their rather strenuous laws dealing with the Fair Debt Practices Act. The lawyer and even the creditor can get in trouble if such regulations, law, are not strictly adhered to. I like sleeping at night. So retail is fraught with concerns. So my first advice is, if you're dealing with retail claims, do get